Welcome to the Omar Alayli podcast, your go-to podcast for exploring the diverse fields driving space exploration and technology. I'm your host, Omar Alayli, and today we'll be talking about space law with Dr. Elena Cirkovic, whose research explores how the Earth and outer space are interconnected, especially when it comes to sustainability and legal challenges of the future. She's worked with reputable institutions like the Max Planck Institute, University of Helsinki, and currently at Aarhus University School of Law. Elena, thank you so much for joining us today.
Hi, thank you, Omar, for inviting me.
Elena, let me ask you a basic question from an engineer's perspective. Someone might think, we have international law. Why would we have a need for space law?
So it is a fairly wide question and a wide topic, so I'll try and narrow it down. Technically, we do have space law since the 1960s, since the advent of activities in outer space, and the current what we now know as Outer Space Treaty has its origins in the Cold War, and it was initially a necessity in response to the advent of the space age, and especially because we had two major players in international politics starting the space age. So that need was always recognized, although possibly for different reasons. So in the kind of Cold War era, sorry, there were lots of concerns about also then the questions of the province of mankind, or province of humanity rather, the commons, but also military competition and so on. So this is we do already have what in law we would call like a special regime. And it is specifically for space. And just to clarify what I mean by special regime is if you think of international law, it's international law for international for governing international relations. But because we also have so many different issues that cannot all be lumped into the same area of law, we then have special regime or expert regimes ranging anything from, let's say, space law to law of the sea and so on. So I hope that helps.
You studied international environment law at the University of Toronto and then did your PhD at York University, Osgoode Hall Law School. What got you interested in space law?
I actually, I was always interested in space. And interestingly, when I was doing, let's say, my studies a while ago in Canada, space didn't seem like an area where I could participate, mostly because I wasn't in STEM. I was always in social sciences and humanities. And over time, just through working in different areas of international law, ranging from international humanitarian law to environmental law, and the Arctic specifically, I started slowly. It was just a natural progression. I started working on space law as an extension of human activity. So, activities in regions like the Arctic, suddenly seeing something similar happening in outer space and just transitioning into a different domain.
For our audience who are not familiar with space law, what kind of issues arise that we need outer space legal norms for?
So, specifically, and this is related to my first answer, because of the nature, because of the kind of historical moment in which the Outer Space Treaty, and I will not go into details on treaties. That's a bit of a separate topic. But the moment that it emerges, there are specific priorities and issues at the time for the international community, right? And over decades, we've seen, and especially recent decades, we've seen the acceleration of activities in outer space, including new actors, new states, private actors like private companies, and so on. And many of those issues weren't codified into law back then. And this includes especially environmental concerns. So while we do have plenty of regimes and at different scales and different levels, ranging from, let's say, regional law, like EU law, for example, national law, anything from US to Canada, whatnot. At the international level, we do have various environmental laws, and now increasingly also climate governance and regulation. But because of what I said initially, that we have specialized regimes in the space realm, there was no very specific and explicit mention and specialization of environmental issues. But one thing also that I do need to mention is that, and I'll try to explain this for the general audience, in the Outer Space Treaty and existing international space law, when we talk about responsibility and liability for any activity, it is automatically and directly a national responsibility.
One of the biggest hurdles we in the space industry face are regulations and policies. In the US, if you're designing space rockets, you have to get them from the FAA. If you're doing telecom, then it's the FCC. And if you're doing remote sensing, it's the Department of Commerce. Where do you stand on international law versus domestic law and regulations?
So this is a kind of a fundamental question of international law, not necessarily space activities, because it's the same as any other topic. Do we have universal human rights laws? Do we have universal environmental laws? And the reality is that we are to use some maybe more archaic approaches, we are an international community of states primarily. And international law has always been, since its inception, state centric. And this is then, over time, there's been, and especially after the Second World War, of course, you have recognition of the individual and therefore like human rights. But when it comes to subnational entities, be it private actors or other non-state actors, it then becomes a more of a blurry realm of just governance. And it doesn't, again, I stress that it doesn't matter whether it's space or anything else. And this would be, I would argue, one of the reasons. And there are scholars, by the way, who are looking in great detail as to all the different narratives and submissions and discussions that took place during the negotiations of the Outer Space Treaty to see, especially between, let's say, more powerful countries, and I don't know, this was also the process of decolonization and so on, to see who forwarded what kinds of arguments. But the consensus at the time was that because it was also such a tremendous activity, like and you would know this better than me as an engineer, you're essentially sending a bomb into space. There's so much at stake that's why one of the reasons that's why they went default into this national responsibility. And then because it was national responsibility and every state had this responsibility, or has rather, and liability, and not to go into details on terms like due regard, due diligence, and so on. That's why especially the spacefaring countries, US, USSR at the time, Russian Federation now, have had these fairly stringent national laws and processes, because it wasn't just something affecting it was a global matter and a planetary matter, and it was recognized as such, I would say, always. So there are two parts to this. There is, of course, the specificities of what space activities are, and how impactful they are on the planetary level. But then there's also the fundamental question of international law, that we always do still have great deference to national laws, because it's a relatively voluntary system.
First of all, congratulations. You have just written a book, The Law of Complex Earth and Outer Space Systems, the Cosmolegal Proposal. What are some of the objectives of the book?
One of the objectives of the book is to go into the questions of what the law is, because in the context of issues like climate change and increasing space activities, we are also seeing novel issues. Many of these have been addressed again at the kind of terrestrial level, under various developments, including, for instance, Earth system boundaries, the concept of Earth system boundaries from the Stockholm University, which I think is really important. then different approaches, including, let's say, Earth system science evaluation. So looking more at the global planetary level. And on top of that, adding now the extension of, again, human activities, because to go back a little bit, saying that there's Earth versus outer space, I always found it a bit weird because we are in outer space, are formed in outer space. So it is the human activities that are extending these issues, the human law. And that, to me, as someone who studied law from our disciplinary perspective, opens all kinds of other questions about law itself. So, what is law? And so that is one of the topics, actually, more fundamentally, versus, let's say, should we have law or not? So I hope that's a bit uh, clear. But yeah, it's that was kind of the new question. I was like, what now? We have all these new issues. Yeah.
So let me ask you, how interconnected are Earth systems and outer space activities, and why do you see this as a complex challenge requiring new legal framework?
Well, in addition to what I said earlier about international law being state-centric, so we call it, let's say, legal pluralism. There are many different notions of legal pluralism, but I'll say there's this one form of legal pluralism where we have many different jurisdictions, so many different state interests. We also have different sectoral interests, different areas. So, as we said before, outer space, environmental law, humanitarian law, etc. And we have this kind of categorization, which is to a great extent necessary because of specialization. So, if I'm working as a, I don't know, environmental lawyer, I should specialize in something. It's easier. But with something, let's say specifically space activities, if you, and again, you know this better even than I do, if you think about the entire process, an entire life cycle of an activity and of space technology, it ranges from all the processes that are necessary on Earth, anything from hiring labor, hiring scientists, to thinking of environmental assessments of construction, design, and all that. And in that sense, I would say it's not terribly different from architecture, for example, or any other design processes. And this is also something that is addressed by the space-enabled research group that I mentioned, I think, to you at some point during the conversations, where they're talking about the kind of full process of engineering and systems architecture and how it plays in relation to other issues like society, environment, and so on. So when you think about it, there's the kind of upward process and everything goes into that. And then there's the downward process of deorbiting, and we can get to that in a moment, and potential environmental impacts on the atmosphere and etc. And there is quite a bit of research on this. It's been going on for some time, but it is now also accelerating more and more.
Can you give us a sense of what the cosmolegal approach is and how it differs from traditional frameworks for international law?
It is informed by indeterminacy. One of the methods, or rather theoretical frameworks, that I employ is complex systems studies. And while to people in STEM it would mean one thing, in social sciences it might mean something else. But also because of increasing research and an ongoing work on complex systems interactions in various disciplines and various domains, there is also a greater acknowledgement of certain unknowns and indeterminacies. And in what we just talked about, the full Earth outer space, let's call it relations or interconnections, this also introduces further variables into these complex systems interactions. And there have been approaches, or rather there have been proposals in law specifically to study law as a complex adaptive system. Specifically, Professor J.B. Rule, already maybe two or three decades ago, started talking about this. But what I am trying to discuss is not to look at how law itself is already a system of a certain kind, which definitely is complex or whatever, but to see how these externalities such as different interactions in Earth systems and whatever, should actually transform the human law itself in order for us to be better suited to respond to some of these issues. So I do have to say at this stage that it gets very much into a theoretical realm as opposed to this is not a book that is going to give very clear sets of policy proposals, but it is trying to understand a kind of a different ontology of law rather. And that is very much informed by complex systems studies.
But still, this book is going to have some kind of informative approach to, if not directly to policymakers, maybe to legal scholars. What do you hope such policymakers and legal scholars take away from this book?
Well, I think it starts a conversation, and also it extends a conversation that's been taking place for some time in law. We do often get into a situation where we want to advance a certain set of laws and policies, and then that we come up against certain existing, let's say, inconsistencies, contradictions. And one thing that I'll say, and this is an argument, this is a very particular legal argument, it is not shared widely, that law is not only informed by the practice itself, but that both practice and law have normative connotations. So what is it that I wish to see in the world? It is kind of a form of world building. And it's not, again, we are not speaking merely of outer space, we're speaking of anything, ranging from, I don't know, bylaws in urban planning. What do you want to see in a city? To, what do you want to see? What do you want to see on a planet, and why? So that is a conversation, and now there is a conversation on what do we want to see in outer space? What is our main priority? What is our goal? What is it that we're extending? And it's not. There is no clean answer to that. It is. There are many different sectors and interest groups and views and beliefs on what this should be.
Very interesting. It's clear that you're very passionate about this subject. Can I ask you what inspired you to write this book, and what gap in space law or environmental discourse does it aim to address?
So what it inspired is that for some time I have worked a lot on international environmental law and environmental law in various contexts, especially in the Canadian context, which is where I studied and lived. But and this is, again, I would not say that it's just me, but as we move along, there is an understanding that there's a social element to law where we are governing or trying to address human interactions, how we live in a society, whether at a national or international level. But with environmental concerns, there is also that external non-human aspect. So again, there is a wealth of scholarship that is I wouldn't even say only past, let's say, century, but there are different origins, there are different forms, and this is why there is a recognition in my book also of different knowledges, different traditions of knowledge, including, let's say, indigenous people's knowledges and so on, how we understand what law is in relation to the non-human. But so with climate concerns, for instance, among others, this has been increasingly a topic in certain legal scholarship circles. But and then with outer space, you just add another level. So there are so many concerns about what is happening on Earth, what is our relationship to the environment, how does law function in this environment, considering human laws versus, let's say, laws of physics or whatnot. But then now you also have the extraterrestrial dimension. And what does this all mean once we are also engaging in outer space activities? So maybe one thing that I would like to, maybe if the audience is to take away anything, we talk a lot about the novelty of outer space, the novelty of all these new activities, and how do we think about the law over there, whether we're thinking about um, interstate relations and military activities, or construction, like lunar construction, which is what I'm slowly trying to get my head around and to understand all the engineering and science behind it. But if you think about it, who is doing all of that? It's us, quote unquote. It's humans, it's humanity. So we are merely extending our activities to another domain. So I would always ask, instead of thinking, what should be the new laws on Mars or the moon or wherever? Why should they be? What are the laws anyway? Do you see what I mean? Like, what is our relationship to the environment, be it here or on Mars? What is the conceptualization of human rights or responsibility or liability and so on. So whether we're talking about the deep sea, for example, or the Arctic or whatnot, I would merely extend that. And so I would not necessarily argue that we don't have any law and that we need something completely new, but that we need to continue discussing and interpreting and developing already in the kind of more of a continuum.
Cool. So yeah, basing on what you just said, we already have the Outer Space Treaty, we have the Rescue Agreement, we have the Liability Convention, the Registration Convention, and the Moon Agreement. Do you think, based on what you're saying, we need another now? We're due for another international agreement?
Uh, yes, in part. These things take a very long time because we have to work. There has to be some kind of consensus. There has to be a process. There's a lot of diplomatic work. Um, Most of the proposals come from the need to have better regulation of non-space actors. Non-state actors, not non-space actors. So private actors, for example, because again, Outer Space Treaty doesn't really have specific. It does talk about state responsibility, and this includes responsibility for subnational actors. But there is nothing separate only for private actors as such. There have been new attempts at developing slowly different types of agreements. If we think of Artemis agreements, which are not a treaty, they're a set of kind of bilateral mutual agreements between states, and more states are becoming a part of this, but I would leave it aside as a bit of a murky legal area for now. So yes, but at the same so I would say yes. However, I would say that we also have this notion of regime interaction and regime integration. And when you asked all the way back about international law, and this is kind of this is a topic within international law as such. And it's this question of kind of hierarchies in international law and the relationship among different regimes. And maybe I can give you a very specific example. If you think about, let's say, just a national context, and I can give you a Canadian context, if we Charter of Rights and Freedoms. So is my right more important than your right? And there is always this balancing process taking place. So my right to, I don't know, free speech versus something else, right to freedom of religion, whatever. And so it goes to kind of case by case basis and interpretation. And there are different areas of law that might take place in this. Like, is it a labor dispute? Is it an environmental dispute? In Canada, Indigenous, self-determination and so on. So if you extend that to the global and even further in outer space, we do have so many different regimes that are there that govern all different aspects. And there is the most recent example from the tribunal for the general audience. It's a tribunal for the law, International Tribunal for the Law of the Sea. And there was a very recent advisory opinion, by recent, I mean May 2024, which purposefully interpreted both various climate agreements, like the Paris Agreement, with UNCLOS, the UN Convention of the Law of the Sea, and expressly specifying how various activities in one domain affect another. And so what I mean by that is we can and could, and this is one of the things I say in my book, we can and could do that in outer space as well. So while we do need new laws, potentially, and yes, most likely, we also do have all these different bodies of laws that can be interpreted and will be most likely in the future. It is just that, and this is maybe also another thing to take away, because of the nature of those activities, it is not something that not everyone goes to space. Not everyone is part of this science and the process, right? It's like, so it's not exactly the same as maybe something that's more accessible. So we don't actually have case law. We don't have, if you look at the law of the sea, we have tremendous case law precedents and things to look at. We don't have that in space. And I think that's something that is going to be developing slowly over time.
In a way, those treaties have mostly been reactionary, promoting free overflight in space and concepts like no sovereignty in space. I'm wondering, will the advent of potentially starting to mine on the moon force the international community to make new treaties?
Yes, very likely. As I said, it is those debates and discussions are already underway. And Artemis Accords, I think, started them because it's sort of there, and not just Artemis Accords, but various jurisdictions have, like Luxembourg, US, have Japan, and so on, are expressly referring to new activities, including commercial activities, and what that might entail. And I will stop there because it's a different area of law. But so yes, it is law tends to react to developments. At the same time, there is a precautionary approach as well, and this is something that's mentioned quite a bit in environmental. This is where environmental law comes in, the notion of precaution, because there is, um, if we think of, you mentioned nuclear weapons, prohibition of nuclear weapons. If you think of the historical context, of course, Cold War, this is a big priority. It's a priority even now. What about the environment? What about the lunar surface? What about all these other questions? And as we kind of shift over to those, new things start to develop, but also new existing areas of law start to get triggered, so to speak. And I refer to environmental law because while heavily debated and not always established as firm global rules or principles, there are different principles, like again, the precautionary principle, which comes from the environmental law, mostly because of this recognition that we are dealing with environmental processes. We're dealing with potential unknown, unpredictable responses. What will happen if we do something near the river X? Is it going to flood, and will this affect all the communities, and so on? So that is something, and I mentioned this also in the book, and there has been literature in law on this, on how to think of outer space, for instance, from that type of lens. But I work mostly in the environmental law area, so there's that concern. But you can also extend it to different other areas. What if you now have settlements? What kind of employees do you have in outer space, right? What is their status? What is many, the entire chain of, procurement, or just to go into even small administrative matters. So all of that is now rethought and negotiated, and there is borrowing and trying to understand. And actually, very quickly to say, EU is currently, well, it was about to propose, and it's been somewhat delayed, but also EU space law, so that there is a regional, and I would say that that would be one of the um, important initiatives, because if an entire region comes to a consensus on what this, it might also compel others to engage in this kind of lawmaking.
From space law and environmental law's perspective, how significant is the issue of space debris today, and what are the potential dangers it poses?
It is very significant, yes, environmentally, but also from other perspectives, because it has multiple impacts all at once. One is obviously environmental, the congestion, the acceleration of this congestion. And then another one is beyond just, let's say, what does it mean for the orbital environment? And there is also, what does it mean for other space actors, other space objects, the potential for impact? Then this will also affect, of course, design, and to what extent design now needs to really take this seriously and to ensure that, whether how to avoid impact, etc. So I would say, it touches on obviously the existing space law, but also and environmental law, but also potentially so many other areas of regulation, because space debris can have more than one result. One is, obviously, we think now about the environment, but then what does it also mean for other space actors, other space, my satellite versus your satellite, and so on, to be somewhat, I don't know, simplistic about it. Yeah. Um, and this is where, actually, for someone like me, coming from social sciences and humanities and arts and whatever, learning from engineers has been really valuable, to try to really understand the dynamics of what this means. We hear a lot. People always ask me when I talk about this, if when will things start falling on our heads? and one, and while that is, that there is that kind of possibility, it is not. That is not, of course, the when I look at it, it's not my number one, consequence. There are so many orbital consequences, atmospheric, and so on. So yeah, it's more than just to, yeah.
Are there any developments that are specifically tailored to mitigation of space debris?
So there are, yes, and this is also just to give a little bit of a primer on, the nature of international law. When we think of something like Outer Space Treaty, it is a treaty, and all the signatories to the treaty are bound by that treaty, and this is something that we would, let's say, refer to as hard law, as enforceable law. Again, whatever that means in the international legal realm. But then, because of these developments, environmental and otherwise, there have been initiatives. And this is where we now enter into what is called the arena of soft law. And the UN Office for Outer Space Affairs has been always the umbrella under which we've seen a development of various, let's say, guidelines and proposals. So an obvious example would be the LTS, so the LTS guidelines, or the long-term sustainability guidelines for outer space activities, and under the Committee of the Peaceful Uses of Outer Space of UNCOPUS. And so what that then opposes is, it opens a debate. Well, if there are guidelines, they are not enforceable law. What does this mean? And what it could mean is that the more they become applied in various, for instance, like what we discussed about EU law initiatives or national legal initiatives, the more these guidelines become incorporated or applied into into ongoing law and policy making, be it a national level, or regional, or international, the more we're going into what we call the realm of customary international law. And so there is a question whether some of these new guidelines, let's say, as an example, are helping develop new customary law. And customary law, and again, I'm going back into the basics just for a broader understanding of what all this means in terms of processes, because I cannot say, yes, there are guidelines, there are LTS guidelines for outer space activities, and now they apply to everyone. They don't, but and I would get all kinds of arguments for saying they don't. But the reality is that there is a voluntary process by individual states, or in the context of EU, there's the regional governance, to incorporate that into their national laws. And once they're incorporated into national laws, then they enter into that realm of legal precedent. There's a development through the law, if that makes sense. And customary international law is exactly what the title says, or what the words say. It's a law that develops through custom, develops through practices. So something might be proposed at a point X, and it's not immediately a treaty, it's not a rule, but then over time, through practice and incorporation in different decisions, or let's say courts and tribunals do this as well, if they incorporate something into their specific decisions, then it can become part of, or it does inevitably become part of what we consider as, applicable law, or sorry, enforceable law. So that is the kind of something I have to explain without saying, yes, this is now, this is the new regulation. It is a process, I would argue. So, but yes, there's been now, as you mentioned before, it's a kind of, there's been a response, and it is coming from different. We have, every year at UN Copus, there is, especially in the legal subcommittee, there's quite a lot of discussion and debates on what to do next, and how to how to proceed with the regulation in outer space. So it is, and I will say this again, for the non lawyers. When I teach international law, for example, and especially to let's say first year students, there's always this question of like, so what can international law do for issue X? And it's always disappointing where I come with a fairly vague response of, it depends. It depends on the context. So it goes on case by case basis. A lot of deliberation and decision making that takes place, and diplomatic considerations. So that is just the nature of the, let's say, the international and global realm.
Elena, you've been very active this year. You're also just finished a residency, an artist residency. I've seen some of your artwork before. What is this residency about, and is it related to space law?
Well, it is not directly, sorry, it's not directly related to law per se, but it is related to my broader interest of these kinds of Earth outer space relations and human non-human communication. I've been working in visual arts always in some way or other. And after my PhD, I decided to study landscape architecture for a while, but it was a fairly exhausting, as an architect, I think you can relate. It was an exhausting process, which was set aside. So I decided to start a second PhD in art and design at the University of Lapland. And the focus of my PhD is kind of trying to think of, again, human, non-human communication, and through art-based methods, a lot of bioart, and that was the residency with the Bioart Society in Finland, in Helsinki. Um, and most of my colleagues there do very different levels of bioart, ranging from, and I don't do this, ranging from, uh, dealing with different organisms, or just from manipulating nature to leaving it alone, to it's quite vast. And but yeah, so I'm kind of translating the exact questions that trying to deal with in law to my interest in arts and design. So that is kind of the most general as general as it can be answer to that. Yeah.
What do you think the future looks like for space law in light of the new technologies and commercial ventures like space mining, space manufacturing, and tourism in space?
There will be inevitably, yeah, assuming that the international law itself continues as what we think of it today. Because also think of one thing to note, a historical thing to note: the notion of international law and the structures of international law that we have now are relatively, in the kind of deep time context of things, relatively new. We're thinking since after the Second World War. And so, assuming that we're working still in the same context, there will be inevitably developments, legal developments, potentially new novel treaties, new types of interpretations, because as activities continue, these activities will result in various events, consequences, interactions, which might result in disputes and need for resolution of those disputes and so on. So as that progresses, I would argue that law will follow, be it at international level or at domestic level.
How do you think international law should adapt to ensure that space remains a shared and sustainable resource for all?
Well, so a couple of answers to that would be obviously my opinion, and this is related to my work and general normative thinking, is that there needs to be a certain level of prioritization of environmental sustainability, because this will impact access of all humanity to space, not only now but also in the future, for both for sorry, for different types of activities, ranging anything from scientific research to commercial activities and so on. And this is also, I would say, something that was a topic and is in Outer Space Treaty, because there is a mention um, of humanity and space being accessible to all of humanity, and not just in the present but also in the future. So even if in 60s and 70s there wasn't a very explicit mention of something like space debris or the rights of future generations, as we are talking about them now in let's say in the context of climate and environmental concerns, I would say that the intention, and this is also somewhat, there is always a debate on what was an intention behind the treaty. It's not just what it says, but what might have been an intent behind it. So I would argue that this is part of that intent. So that while will, and I repeat myself, while we will have and law will develop and there will be most likely new agreements, um, that we're not starting from scratch on that, and that this kind of awareness and of what these activities might imply has always been there. So it is maybe more of a matter of prioritizing certain topics or concerns versus others. And obviously in my work and for me, I focus on environmental sustainability.
And as we wrap up, I'd love to hear your final thoughts or advice.
Well, the final thoughts I would say would be a wrap up of everything we've discussed. I do argue, and based on my professional and academic knowledge and experience, that there is a need for more holistic and maybe more integrated and also transdisciplinary work, for greater collaboration among different disciplines. Being in law, we do often see this gap, not just, let's say, between law and science, but even between different areas of law, if somebody's working in public versus private. So for something that is at such a scale, at the planetary and also interplanetary level, I think it's inevitable and necessary to engage in more transdisciplinary work, greater collaboration at different levels. And I'm not saying this only for the international realm, so when I speak of international law, but also just at all levels. So we do go from very particular matters of analyzing what will it mean for a person to live in outer space, for example, and what does it mean for their rights and duties, and I don't know, societies and so on, but also going to kind of a broader understanding that it is a combination of. So we do have to specialize, but I would argue that we also increasingly need to have broader and more integrated knowledge.
Elena, where can our audience find you or follow you?
Well, I'm available online, either on my departmental website, the University of Aarhus, and where also they can find further information on what I do, what I've published, etc. I'm also on LinkedIn. Albeit I'm more responsive through email than social media. Bit of a, I still live in the forest in a way. So, but yes, I think these days we're all online, so I am easily located, for better or for worse.
Well, Elena, thank you so much for joining us today. It's been a pleasure having you on. And for our audience, This is Omar Alayli, and you've been listening to the Omar Alayli podcast. Keep exploring.